Hello everyone, we reached to chapter 2, Parliament of chapter of part 5, the Union. General clauses including Article 79, Constitution of Parliament. There shall be a parliament for the Union which shall consist of the President and two houses to be known respectively as the Council of States and the House of People. According to Article 79, the Parliament of India consists of the President, number 1. Number 2, the Council of States, Rajya Sabha, also known as Upper House. Number third, the House of People, Lok Sabha or the lower house. Article 80, composition of Council of States. Clause 1, the Council of States shall consist of 12 members of to be nominated by the President in accordance with the provisions of Clause 3 and be not more than 238 representatives of the states and of the Union territories. 238. Clause 2. The allocation of seats in the Council of States to be filled by representatives of the states and of the Union territories shall be in accordance with the provisions in that behalf contained in the fourth schedule. Clause 3. The members to be nominated by the President under subclause A of Clause 1 shall consist of persons having special knowledge or practical experience in respect of such matters as the following, namely literature, science, art, and social service. Clause 4. The representatives of each state in the Council of States shall be elected by the elected members of the Legislative Assembly of the state in accordance with the system of proportional representation by means of single transferable vote. The representatives of the Union territories in the Council of States shall be chosen in such manner as Parliament may by law prescribe. So, about this article, the article lays down the provision for the composition of Council of States, which comprise of two classes of members. Firstly, 12 members to be nominated by the President having special knowledge or practical experience in literature, science, art, and social service. Literature, science, art, and social service. Secondly, representatives of the state and union territory, which shall not be more than 238. So, the representatives of the states are elected by the members of the Legislative Assembly in accordance with the system of proportional representation by means of the single transferable vote. The representatives from the union territories are chosen in such a manner as Parliament may by law determine. The allocation of seats in the Council of Ministers to each state or union territory are specified in the fourth schedule of the Constitution. The Council of States is a permanent body. Its members are elected for a period of 6 years, but one-third of its members retire after every 2 years. For Nota, in Shailesh Manubhai Parmar versus Election Commission of India, and others, 2018, the Supreme Court held that introduction of Nota, none of the above, in the Rajya Sabha elections would undermine the value of party discipline, create space for corruption, and encourage defection. Nota was introduced for direct elections where one person's vote would have only one value, but implementing it in representative form of election where elected candidates choose a representative for an entire state by open ballot could prove dangerous to party discipline and is capable of promoting defection and corruption in the process. So, Article 81, furthermore, Article 81 furthermore talks about the composition of the House of the People. House of the People, as you remember, is Lok Sabha or the lower house. Clause 1. Subject to the provisions of Article 331, the House of the People shall consist of A. Not more than 530 members chosen by direct election from territorial constituencies in the states, and B. Not more than 20 members to represent the union territories chosen in such manner as Parliament may by law provide. Clause 2. For the purposes of subclause A of Clause 1, Clause A, there shall be allotted to each state a number of seats in the House of the People in such manner that the ratio between that number and the population of the state is so far as practicable the same for all states. And B. Each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allocated to it is, so far as practicable, the same throughout the state, provided that the provisions of the subclause A of clause shall not be applicable for the purpose of allotment of seats in the House of the People to any state so long as the population of that state does not exceed 6 millions. In this article, the expression population means the population as ascertained at the last preceding census of which the relevant figures have been published, provided that the reference in this clause to the last preceding census of which relevant figures have not been published shall, until the relevant figures for the first census taken after year 2026 have been published, be construed first for the purpose of subclause A of clause 2 and the proviso to that clause as a reference to the 1971 census, and second for the purpose of subclause B for clause 2 as a reference to 2001 census. This article states that the House of People shall consist of not more than 530 members chosen by direct election, not more than 20 members representing the Union territories, not more than two members belonging to the Anglo-Indian appointed by the President. And now this provision is removed by the 104th Constitutional Amendment Act 2019. This provision was for 70 years as amended earlier and it expired in 2020, and as there is no extension, so there will be no more nomination of Anglo-Indian. So in totality, there are 550 members in the Lok Sabha. For the purpose of elections to the Lok Sabha, each state is divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it as far as practicable is same throughout the state. Thus, uniformity of representation are in two respects: A as between the different states and B as between the different constituencies in the same state. By 84th Constitutional Amendment Act 2001, the population data right now is construed in 1971 census figure till the year 2026. Article 82, readjustment after each census. On the completion of each census, the allocation of seats in the House of the People to the states and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as Parliament may by law determine, provided that such readjustment shall not affect representation in the House of the People until the dissolution of the then existing House, provided further that such readjustment shall take effect from such date as the President may by order specify, and until such readjustment takes effect, any election to the House may be held on the basis of the territorial constituencies existing before such readjustment. Provided also that until the relevant figures for this first census taken after the year 2026 have been published, it shall not be necessary to readjust. Firstly, the allocation of seats in the House of People of the states as readjusted on the basis of the 1971 census, and second, the division of each state into territorial constituencies as may be readjusted on the basis of the 2001 census under this article. Article 83, the duration of Houses of Parliament. Clause 1, the Council of States shall not be subject to dissolution, but as near as possible, one third of the members thereof shall retire as soon as may be on the expiration of every second year in accordance with the provisions made in that behalf by Parliament by law. Clause 2, the House of the People, unless sooner dissolved, the House of the People, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting and no longer and the expiration of the said period of 5 years shall operate as a dissolution of the House, provided that the said period may, while a proclamation of emergency is in operation, be extended by Parliament by law for a period not exceeding 1 year at a time and not extended in any case beyond a period of 6 months after the proclamation has ceased to operate. About the Article 83 contemplates that the Council of States is a permanent body and one third of its members retire after every second year. The House of the People, if not dissolved before by any reason, continues for 5 years, but its duration may be extended if the proclamation of emergency is in operation. It may be extended by Parliament by law for a period not exceeding 1 year at a time and not exceeding 6 months after the emergency has ceased to operate. Clause 84, Article 84. Qualifications for membership of Parliament should be noted very clearly. A person shall not be qualified to chosen to fill a seat in parliament unless he is a citizen of India and makes and subscribe before the person authorized in their behalf by the election commission an oath or affirmation according to the form set out for the purpose in the third schedule. Subclause B is in the case of a seat in the Council of States not less than 30 years of age, and in the case of the seat in the House of the People not less than 25 years of age, and possesses such other qualifications as may be prescribed in their behalf by or under any law made by Parliament. So this article lays down the following qualifications required for a person to be chosen as a member of Parliament MP. He must be a citizen of India. So these are the negative connotations given in the article. I am telling you the positive connotation. Firstly, that he must be a citizen of India. He must make and subscribe to an oath or information before the person authorized by the election commission for this purpose according to the form set out for the purpose in the 10th schedule. He must be not less than age of 30 years in case of age in case of Rajya Sabha, and not less than 25 years of age in case of Lok Sabha. So a member of Lok Sabha can be made after age of 25 years, and a member of Rajya Sabha can be made out of after 30 years of age. The Representation of People Act 1951 requires that he must be registered as an elector for a parliamentary constituency, for any parliamentary constituency, possesses such other qualifications as may be prescribed in their behalf by or under any law made by the Parliament. About Article 85, Sessions of Parliament, Prorogation and Dissolution. Article 85, Clause 1. The President shall from time to time summon each House of Parliament to meet at such time and place as he thinks fit, but 6 months shall not intervene between its last sitting and in one session and the date appointed for its first sitting in the next session. Second, the President from time to time A. Prorogue the houses of either house or either house, B. Dissolve the House of People. So the President has been conferred with important functions of summoning, propagation and dissolution of the houses of parliament. The term summoning means calling up the house, that is, its convocation when it is considered necessary. The term prorogation means an end to parliamentary session, which can only be given effect to by the president. Third, the term dissolution means the end of the life of the House of the People and call for a fresh general election to elect a new house. Article 86, right of president to address and send messages to the houses. Clause 1. The President may address either House of Parliament or both houses assembled together and for that purpose require the attendance of members. Clause 2. The President may send messages to either House of Parliament, whether with respect to a bill then pending in Parliament or otherwise, and a House to which any message is so sent shall with all convenient dispatch consider any matter required by the message to be taken into consideration. Note the words Parliament the President shall address means that it is binding on the President to address both houses of Parliament assembled together at the commencement of the first session after each general election of the House of the People and at the commencement of the first session of each year. Article 87 was all about this. That is special address by the President. It states that at the commencement of the first session after each general election to the House of the People and at the commencement of first session of each year, the President shall address both houses of Parliament assembled together and inform Parliament of the causes of its summon. Clause 2 provision shall be made by the rules regulating the procedure of either house for the allotment of time for discussion of the matter referring to in such address. So the special address of the by the President means that it is binding on the President to address both houses of Parliament assembled together at the commencement of the first session after each general election of the House of the People and at the commencement of the first session of each year. Article 88. The right of ministers and attorney generals as respects houses. Every minister and the attorney general of India shall have the right to speak in and otherwise to take part in the proceedings of either houses, any joint sitting, of the houses, and any committee of parliament of which he may be named a member, but shall not by virtue of this article be entitled to vote. So all the ministers and attorney general shall have the right to speak in and take part in the proceedings of either houses and in joint sittings of the houses and any committee of parliament of which he is a member. The right given to a minister or the attorney general of India under this article is of participation but not of voting. A minister cannot vote only in the house of which he is a member, though he is entitled to participate in proceedings of the other houses. And I'm very thankful to read this article as I got to know about the exact information I was looking for about Attorney General of India.